Topics in the country at the moment, and that is, of course, the Timothy Omotoso case. Now, proceedings in that Omotoso trial took a turn yesterday. The presiding judge, Mandela Makaula, dismissed an application by the defense team that he should recuse himself from the case. Omotoso's lawyer, Advocate Peter Daubermann, accused Makaula of being aligned with the witness, Cheryl Zondi. So, to discuss this further and help us just unpack and understand the legalese around it, we are joined now from our Port Elizabeth studios by Vinesh Naidu, who is a High Court Legal Practitioner with Legal Aid South Africa. Vinesh, thank you so much for your time this morning.
Good morning, Sakina. It's wonderful to be here and to join you guys this morning.
Vinesh, let's start here. Did yesterday's turn of events take you by surprise at all?
Not at all. I must be honest with you. You know, this is one of those cases that has grabbed the public's attention, not only because it highlights the issues of sexual abuse and rape and all of that, but more because of the volatile nature of the proceedings and the sometimes volatile banter between the presiding officer and the defense counsel in the matter. It was foreseeable that the defense counsel would have taken issue with His Lordship Justice Makaula with regards to some of the comments that he made. So it's not surprising that he brought the application as he did yesterday.
So for those of us who are not of a legal persuasion, I mean, many questions arise from what took place yesterday. Like, for one, how often do we see situations like these where judges are asked to recuse themselves from cases? Is it a common occurrence?
It does happen at times, Sakina. One must take into account that in our legal system there's an adversarial approach between the state having to prove its case against an accused person. Now, the test is, and it's laid down by a court, that if the accused feels that there's a reasonable apprehension of bias by the presiding officer against him, then he can bring such application. But the onus is on the accused because there is a presumption of impartiality by the presiding officer. And I think in this particular case, Sakina, because of the nature of the cross-examination and the vociferous and volatile nature of the cross-examination by defense counsel against Mrs. Zondi in the matter, it raised certain issues of, how we treat witnesses and whether, aren't witnesses given the necessary protection and dignity and respect as should be afforded. And, in these circumstances, the judicial officer has to, at times, intervene. Now, that can be construed as biasness, or it can just be that the judicial officer, in his wisdom, has decided to play a part in not protecting the witness, but making sure that justice is done as between the accused and the witness.
So when we look at bias, are there any circumstances in law under which a judge should then recuse themselves?
Look, if there's any issue of biasness, for example, if the judge enters the proverbial legal arena and starts taking over cross-examination or preventing counsel from asking questions to a witness, then that could be construed as a clear case of a definite bias. In the present case, where His Lordship Justice Makaula, in dismissing or excusing the witness, sort of gave us certain words of encouragement, that, in my opinion, does not mount to a clear case of biasness on the part of the presiding officer.
So is that, in a nutshell, the test for bias that would be applied?
Yes, it would be whether a reasonable person in the position of the accused objectively has or provides evidence to the extent that the presiding officer has formed a biasness against him, and as such he is prejudiced in his case going forward. That is the test. So if we apply to the present circumstances, all that the defense counsel is relying on is the comments made by His Lordship Justice Makaula in excusing the witness.
Vinesh,
so the question has to then be asked, is that sufficient?
And also, what would be the meaning, one, and two, the implication if like in this instance, Judge Makaula were to recuse himself?
Well, the procedure from here on in is that obviously Judge Makaula has dismissed the application. The defense counsel is within his rights to appeal that decision, most probably to the Supreme Court of Appeal. And if he does indeed do that, then the proceedings are halted until such time that the Supreme Court of Appeal makes a determination as to whether there are indeed sufficient grounds for His Lordship Justice Makaula to recuse himself.
So it's very interesting at this stage, and that, of course, will prolong the proceedings from here on in. But do you think that there's any validity in Daubermann's argument that he has presented?
My personal opinion, no. The reason I say that is that in terms of the Constitution, an accused has a right to a fair trial. But on the flip side of the coin, and most importantly, a witness and a complainant needs to be treated with dignity and respect. And, you know, and there's many people, and the public for the first time is you know, up in arms because of the way in a manner that a defense counsel cross-examines a witness, and he's well within his mandate to do that. However, as an officer of the court, the defense counsel also has to treat a witness with dignity and respect. Now, the presiding officer, His Lordship Justice Makaula, in my opinion, returned a modicum of dignity and respect to the witness and gave her a form of encouragement, because in such matters, you know, it takes a phenomenal amount of courage to come to court to testify in front of a public audience, and more so in social media, and to have undergone the rigorous grilling that she had to endure from the defense counsel, who was within his right to do that. But where it sometimes gets overzealous in terms of cross-examining a witness, you know, the court has to intervene to a large extent and make sure that justice is done. So in my personal opinion, I do not believe that Justice Makaula acted in a manner that formed biasness. And one must remember that this is only the first witness. The justice has to make a determination as to the evidence of the witness in totality of the complete evidence that is presented to the court. So it is quite, you know, it was too early for the counsel to have brought the present application.
And just a final question. What was also very interesting yesterday was how Daubermann spoke about social media, trial by media, and outside influences on this particular case, which I thought was curious. But of course, the disclaimer is, I know nothing about the law or anything that goes on in those circles. But, you know, what did you make of that?
Yeah, look, I think what Mr. Daubermann was possibly alluding to is the fact that members of the public do not understand the machinations of legal proceedings and in cross-examination and the right of cross-examining. And I think perhaps he was alluding to the fact that you know, people aren't aware of this, and that they're drawing opinions from the media with regards to the evidence of Ms. Zondi as she had testified. But one has to remember that we are dealing with a presiding officer with many years of experience, and all judges have the necessary experience. Hence, there is the presumption of impartiality. They will not be influenced by the so-called court of public opinion. They will make a determination according to the facts placed before him and what the law says, and make a determination on that.
Well, Vinesh, thank you so much for that clarity, much needed this morning. And thanks so much for being with us. And that was Vinesh Naidu. And he, of course, is High Court Legal Practitioner with Legal Aid South Africa. And this pertains to our question of the day as well. Very interesting developments in that Timothy Omotoso case. All right, let's go to a